A federal courtroom just became the stage for one of the most severe judicial rebukes ever delivered to a former president. A sitting federal judge publicly declared that Donald Trump had deliberately and unmistakably violated a direct court order, using language so sharp and uncompromising that seasoned legal observers described the moment as extraordinary. This was not a routine procedural dispute, not a gray area disagreement over interpretation, and not a minor infraction that could be brushed aside. The judge made clear that Trump had done precisely what the court had explicitly forbidden him from doing, and that the evidence proving it was overwhelming. According to multiple reporters inside the courtroom, the judge's tone shifted dramatically as she laid out her ruling. Her voice rose, her language hardened, and the courtroom fell silent as she accused the defendant of showing flagrant disregard for the authority of the court. She described Trump's conduct as an act of contempt, not merely in the technical legal sense, but as an affront to the justice system itself. Trump, seated at the defense table, reportedly appeared visibly angry, leaning forward in his chair while his attorneys scrambled to manage the moment. This was not just another legal setback for Trump, and it was not a symbolic reprimand. A federal judge formally found him in contempt of court, imposed a $250,000 fine, and issued an explicit warning that future violations would result in custodial sanctions. In plain terms, the judge put a former president on notice that jail time was now a real and immediate possibility. To understand why this moment is so significant, it is necessary to understand how the case reached this point and why the judge's reaction was so forceful. Trump is facing federal charges related to his handling of classified documents after leaving office, a case that has been building for months under intense public scrutiny. From the outset, the court has been acutely aware of Trump's unique position, his massive public platform, and the risks that unchecked public commentary could pose to the fairness of the proceedings and the safety of witnesses. Early in the case, the judge issued a protective order. This was not an unusual move. Protective orders are common in cases involving sensitive evidence, classified materials, or vulnerable witnesses. The purpose is straightforward: to prevent defendants from publicly disclosing information that could compromise the case, influence potential jurors, intimidate witnesses, or endanger individuals involved in the proceedings. In this instance, the order explicitly prohibited Trump from discussing certain categories of evidence, identifying witnesses, or revealing details of classified materials that were under seal. According to reporting from Politico dated December 8, the protective order was written in clear, unambiguous language. It spelled out exactly what Trump could and could not say. There was no room for creative interpretation. Trump's attorneys reviewed the order, acknowledged its terms, and formally agreed to comply with it. The court went out of its way to ensure that the restrictions were tailored carefully, balancing Trump's First Amendment rights with the court's obligation to protect the integrity of the trial. For several weeks, Trump largely complied, though not without testing the boundaries. On Truth Social, he posted comments that skirted the edge of what was permissible, often framing his remarks as general political grievances rather than direct references to the case. Legal analysts noted at the time that the posts appeared calculated to provoke without quite crossing the line, a familiar pattern in Trump's legal history. That restraint did not last. On December 10, Trump published a series of posts that prosecutors immediately flagged as clear violations of the protective order. According to CNN legal analysis, these posts went far beyond general commentary. Trump named a confidential witness by full name, disclosed details about classified evidence that was under seal, and made statements that prosecutors argued could expose individuals to harassment or worse. Screenshots of the posts were preserved, time-stamped, and entered into the court record. This is the moment when the situation escalated from concerning to explosive. Violating a court order is not a political disagreement. It is not protected rhetoric. It is a direct challenge to judicial authority. In federal court, contempt findings are among the most serious tools judges possess to enforce compliance. For ordinary defendants, such violations often result in immediate detention. Judges rely on the assumption that their orders will be obeyed. When they are not, the legitimacy of the entire process is at risk. The hearing on December 12 began calmly, according to reporters from CBS News who were present in the courtroom. Prosecutors methodically presented their case, walking the judge through the protective order and the offending posts. They displayed screenshots on courtroom monitors, pointing out the exact language Trump used and matching it to the precise prohibitions in the order. The timestamps left no doubt about when the posts were made. Trump's attorneys attempted to defend their client by arguing that the posts constituted general commentary and that Trump retained First Amendment rights to speak publicly about his case. They suggested that the language did not amount to specific violations and urged the court to interpret the order narrowly. The judge listened carefully, asked pointed questions, and gave no indication of her ultimate conclusion. Then the tone of the hearing changed completely. According to reporters from NBC News, the judge called up the protective order on the courtroom screen and began reading it aloud, line by line. She did not paraphrase. She did not summarize. She read the text verbatim and then compared it directly to Trump's posts. The contrast was stark. Where the order stated that the defendant shall not disclose the identity of witnesses, Trump had named an individual outright. Where the order prohibited discussion of classified materials under seal, Trump had described specific documents. There was no ambiguity. There was no plausible deniability. The courtroom reportedly went silent as the implications became unavoidable. When Trump's lead attorney attempted to interject, the judge raised her hand and stated firmly that she was not finished. She then turned directly to Trump and addressed him personally. According to MSNBC's legal analyst who was present, this moment was extraordinary in both tone and substance. Mr. Trump, the judge said, do you understand that when this court issues an order, it is not a suggestion, it is not a guideline for creative interpretation, it is a binding legal directive that you are required to follow. She continued, stating that Trump's December 10 posts represented a flagrant and intentional violation of the protective order. She emphasized that the evidence was clear, the language unmistakable, and the violation beyond dispute. This was not a misunderstanding. It was not an accident. It was deliberate defiance. Courtroom observers reported that Trump leaned forward, his face reddening, while his attorneys urgently passed him notes in an apparent effort to prevent an outburst. The ruling that followed sent shockwaves through both legal and political circles. The judge formally held Trump in contempt of court. She imposed a fine of $50,000 for each of the 5 violating posts, totaling $250,000. But she did not stop there. The judge stated unequivocally that if Trump violated the protective order again, she would impose custodial sanctions. In plain language, she warned that the next violation could result in jail time. Legal experts immediately described this as the nuclear option. A federal judge had just placed a former president on the brink of incarceration for contempt. While judges possess this authority, it is rarely exercised against defendants of Trump's stature. The fact that the judge was willing to state it openly on the record signaled that her patience had been exhausted. She explained that she had given Trump every benefit of the doubt. She had tailored the protective order with his public role in mind. She had tolerated boundary testing behavior, but the December 10 posts, she said, left her no choice. The integrity of the proceedings and the safety of individuals involved required meaningful sanctions. This moment did not occur in isolation. It fits into a long and well-documented pattern of Trump clashing with judicial authority. Across multiple cases, in New York, Trump repeatedly attacked Judge Juan Merchan during his criminal trial, posting about the judge's daughter and making allegations of bias. He violated gag orders so frequently that the court held him in contempt multiple times, imposing thousands of dollars in fines. In the January 6 federal case, Judge Tanya Chutkan issued a gag order after Trump attacked prosecutors and potential witnesses. Trump's attorneys fought the order through appeals, securing limited modifications but leaving the core restrictions intact. Trump continued to test the boundaries. forcing the court to intervene repeatedly. In the New York civil fraud trial, Judge Arthur Engoron sanctioned Trump for attacking court staff, including the judge's law clerk, after Trump posted her photograph online with false political accusations. Despite being fined, Trump continued making comments that skirted the edge of the gag order. Even Judge Aileen Cannon, widely viewed as sympathetic to Trump in the classified documents case, issued warnings about improper public statements. Yet across all these proceedings, Trump has operated under the apparent assumption that judges would never actually jail him, no matter how many orders he violated. That assumption may now be facing its first serious test. Legal analysts across the spectrum reacted strongly. Andrew Weissman, former FBI general counsel and veteran prosecutor, stated on MSNBC that this was the clearest warning Trump has ever received that incarceration is a realistic consequence. He noted that Trump has long behaved as though his status placed him above ordinary enforcement mechanisms, and that this ruling directly challenged that belief. Former federal prosecutor Preet Bharara explained that fines, even large ones, rarely deter wealthy defendants. What changes behavior, he said, is the credible threat of jail. Jonathan